Hello and welcome to BYJU'S Exam Prep. Today is Lecture 2 of Target Prelims 2022. We are discussing polity-based current affairs for the Prelims 2022. As we discussed yesterday, we are not only going to focus on the topics which were in the news in 2022 and 2021, but we are also going to impress upon some topics, concepts, issues which were in the news in 2020 as well. But before we start, why don't you press the like button, comment once the video is over, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Let's get started and look at question number 1. According to the Medical Termination of Pregnancy Amendment Act 2021, these are the two questions. These are the two statements. The question is asking, which of these statements is or are correct? Let's look at the background. Till the year 1971, there was no abortion law in this country. That's a very important statement, can be relevant for your prelims exam. It was only in the year 1971 that a law was passed called Medical Termination of Pregnancy Act 1971. And it is this act which was amended in the year 2021. Let's look at what were the important provisions of this law of 1971 and what are these amendments which have been brought about in 2021. Number 1, pregnancy could have been terminated, pregnancy of up to 2 weeks could have been terminated by one registered medical practitioner. One registered medical practitioner, he or she would agree that yes, we need to medically terminate the pregnancy. That means abortion can be allowed up to 12 weeks of pregnancy. But between 12 to 20 weeks, again, abortion could be prescribed, could be performed, but in this case, the requirement is that two registered medical practitioners should agree. What do they agree upon? That this pregnancy is going to affect the physical or the mental well-being of whom? Mother as well as the fetus. So if pregnancy would result in some physical deformity or mental deformity in the fetus, then medically abortion could be prescribed. Abortion can be performed. And if this pregnancy is also going to endanger the physical well-being or the mental well-being of a mother as well, in this situation also pregnancy could be terminated medically according to 1971 law. But in the year 2021, significant changes were made. Which are these changes? Can be important for your exam. Up to 20 weeks, pregnancy can be terminated, but here we require the permission or the approval or the consent of one registered medical practitioner. But pregnancy up to 24 weeks, that means between 20 to 24 weeks can also be performed or the pregnancy can be terminated, but here we require the consent of two registered medical practitioners. This is a very important, significant change. Also, even beyond 24 weeks, pregnancy can be terminated, but for that we require the consent or the permission of a medical board. In 1971 law, it was specifically focusing on married women. Pregnancy can be terminated if the woman is married. But here, even unmarried woman is allowed to conduct or perform this abortion medically if these conditions are satisfied. This is a significant change which has taken place. Let's look at the question. According to the Medical Termination of Pregnancy Amendment Act 2021, a pregnancy may be terminated by a registered medical practitioner or practitioners where the length of the pregnancy does not exceed 24 weeks. This statement is correct, but please keep a note. If the statement was, according to this law, pregnancy may be terminated by one registered medical practitioner up to 24 weeks, this statement is wrong. Because up to 20 weeks, the permission of one registered medical practitioner is required, but between 20 to 24 weeks, we require the permission or the consent of two registered medical practitioners. But since the statement is also talking about practitioners, that makes this statement correct. The pregnancy caused by rape or a failure of contraceptive measure are no grounds for the termination of pregnancy. One important thing in this law is that this law talks about grave injury to a woman. If pregnancy leads to grave injury in a woman, pregnancy can be terminated. Now, this law also talks about that if somebody is subjected to rape and the pregnancy is because of rape, or this pregnancy is because of the failure of contraceptive measures, both these things can be assumed to be a grave injury to the mental well-being of a woman, and as such is a ground for the termination of pregnancy. That means if the pregnancy is the result of a rape, if the pregnancy is the result of failure of contraceptive measures, both of these conditions can be viewed as causing grave injury to the mental well-being of a woman, and as such is a ground for the termination of pregnancy. So this statement, which says the pregnancy caused by rape or a failure of contraceptive measure are no grounds for the termination of pregnancy, this statement is incorrect. The question is asking which of the above statements is or are correct. It's A, only one is the right answer. Let's look at another question. Ordinances have been promulgated by the President during the COVID-19 lockdown. We saw an ordinance which was promulgated by the President specifically targeting or specifically focusing on the healthcare workers. If somebody is assaulting a healthcare worker, for that additional punishment was prescribed. Epidemics Act, it was amended through an ordinance in the year 2020. But at the same time, ordinances have been promulgated by various governors of the states as well. So ordinance making power can be a relevant question for your prelims examination. And you would know that this ordinance making power is available both to the President as well as the governor. President is empowered under Article 123 of the Constitution to promulgate an ordinance. The same power is given to the governor under Article 213 of the Constitution. But what does the Constitution say? If the President is satisfied or if the governor is satisfied, when either one or both houses of the Parliament are not in session, if either one or both houses of the Parliament are not in session, then what President can do? President can promulgate an ordinance. And here you have to keep in mind, if the statement is asking, President can promulgate an ordinance when either one or both houses of the Parliament are adjourned, then this statement is wrong. Why? Because adjournment, it does not terminate the session of the Parliament. Adjournment is only a brief interval in an ongoing session. If the statement was when both houses of the Parliament or when one or both houses of the Parliament are prorogued, because what is prorogation? Prorogation is basically termination of a session. The session is ended. And who has the power to prorogue the session of the Parliament? the President of India, or the governor of a state when it comes to the legislature of that state, when either one or both houses of the parliament are prorogued, then the president or the governor can promulgate an ordinance. President under Article 123, governor under Article 213. But then once both houses of the parliament are convened again, then this ordinance is to be tabled on the floor of the parliament. And once this ordinance is tabled on the floor of the parliament, a bill should be passed replacing this ordinance within 6 weeks of the reassembly of the parliament. That means when either one or both houses of the parliament are not in session, here the president can promulgate an ordinance. This ordinance will continue, and now the session of the parliament has been convened. Once the session of the parliament has been convened, within 6 weeks, this ordinance should be replaced by a law. And if this ordinance is not replaced by the law passed by the parliament, after 6 weeks, this ordinance lapses. That is why we say ordinance is a law, but of a temporary character. It's only for a temporary period. There can be another question in your prelims examination. What is the maximum constitutional validity of an ordinance? And the maximum constitutional validity of an ordinance is 7.5 months. Why? How many days should a parliament be convened in a particular year? It is not mentioned in the Constitution. How many sessions do we have in the parliamentary session? That's not mentioned in the Constitution. Ideally, we have 3 sessions: budget session, monsoon session, winter session. But please remember, these sessions are not mentioned in the Constitution. Constitution does not talk about the minimum or the maximum number of days it should be convened in a particular year. But Constitution has one requirement, that Parliament should meet as often as possible, but in such a manner that the time gap between the last day of session 1 and the first day of session 2, this time period should not be more than 6 months. Which means Parliament must meet at least twice a year, because the time gap between the last day of the first session and the first day of the next session should not be more than 6 months. So 6 months plus 6 weeks, that makes the maximum constitutional validity of an ordinance as 7.5 months. Let's look at the question. The power to issue an ordinance is the executive power of the president as the executive head of the state. Is the president executive head of the state? Yes. Article 54 of the Constitution. It talks about something Article 52, Article 53, Article 54. One of the Article 52, it says there shall be a President of India. That means our constitutional scheme cannot be imagined to function even for a brief moment without somebody occupying the post of the President of India. There shall be a President of India. And Article 53 says all executive powers are vested in the name of the President of India. So President is the executive head of the state. But ordinance making power of the President is not his executive role. It is the legislative power of the President of India. So statement 1 is incorrect. An ordinance cannot be promulgated to amend the fundamental rights. What about statement 2? Is it correct or incorrect? Statement 2 is correct. Which of the above statements is or are correct? B, only 2. Why? Look at Article 13 of the Constitution. What does Article 13 say? There are 4 clauses under Article 13. You don't have to remember these clauses by clauses, but just understand the concept. Article 13 basically says all laws which are in force in this country prior to the commencement of the Constitution, that means prior to 1950, all those laws which were in operation in this country, can these laws continue after 1950 as well? Yes. But they should not violate fundamental rights provided under Part 3 of the Constitution. All those laws which violate fundamental rights will not continue after 1950. And this is where another important doctrine can be relevant for your examination, because this doctrine was also in the news, and that is Doctrine of Severability. What is the important thing here? Let's look at Section 377 of the Indian Penal Code, which was in the news for the past 2 to 3 years as well. It is this judgment which has been cited in various Supreme Court rulings. Section 377 of Indian Penal Code said, and it talked about unnatural offences. Which are these unnatural offences? Whoever voluntarily indulges in sexual intercourse, and this sexual intercourse is against the order of nature, then it will be treated as an unnatural offense, and somebody who is accused, guilty of this, can be sentenced to life imprisonment as well. And it was this Section 377 which was particularly used to target LGBTQ community, lesbians, gays, bisexuals, transgenders, queers. And it was this Section 377 which was criminalizing homosexuality. But then in a landmark judgment few years ago, in Joseph Shine judgment, Supreme Court said Section 377, insofar as it criminalizes homosexuality, it is unconstitutional. But does that mean, and you ask yourself this question, is Section 377 still continuing? Or has Section 377 been declared entirely as unconstitutional by the judiciary? No, it is not. There are still some aspects of Section 377 which continue. For example, bestiality, sex with animals, incest. Bestiality, incest, they are still treated as unnatural offense. So if somebody is proved to be guilty of bestiality or incest, he can be booked under Section 377 of Indian Penal Code. That is what we call Doctrine of Severability. That means this Section 377, which was a pre-constitutional law, if after the commencement of the Constitution, if Section 377 violates Part 3 of the Constitution, fundamental rights, to the extent of that violation, the law shall be declared unconstitutional. That means Section 377, not entire Section 377 has been severed, has been cut. Only that part has been cut which criminalized homosexuality. That means homosexuality is not a crime. But Section 377 can still be used if somebody is guilty of bestiality, if somebody is guilty of incest. That means all laws prior to the commencement of the Constitution, after the commencement of the Constitution, if these laws are in agreement with fundamental rights, these laws will continue. And those parts of this law which violate fundamental rights will be declared unconstitutional. Doctrine of Severability. Another clause of Article 13 makes it clear that the state cannot pass any law, and through this law it cannot delete, it cannot modify, it cannot abridge the fundamental rights provided under Part 3 of the Constitution. But what is this law? It has been explained, examples have been given in Article 13 Clause 3. Law means rules, regulations, bylaws, customs, usages, ordinances as well. So ordinance cannot be promulgated by the President of India to amend the fundamental rights. This statement is correct. Which of the above statements is or are correct? B, only 2 is the right answer. Let's look at another question. Jharkhand and Bihar, they have some tussle regarding the pension, because Jharkhand and Bihar, they were part of one state. The Bihar was a state. The year was 2000. State was reorganized. Jharkhand was carved out from Bihar. And then there is some dispute regarding the pension that should be paid to the employees who were part of this erstwhile big state called Bihar. And now the governments are saying that we will raise this issue in the Eastern Zonal Council. That is why zonal councils are in the news and can be a potential question for your prelims examination. The year was 1956. Prior to 1956, we had different types of territories in India. Territories under Part A, B, C, D. In Part A, we had provinces which were ruled or governed by the Governor General. For example, Madras, Bombay, Calcutta. In Part B, we had those areas which were under the princely states. For example, Hyderabad. In Part C, there were those areas which were previously under the Chief Commissioner. For example, Delhi, Coorg. And in Part D, we had only one territory called Andaman and Nicobar Islands. But this Part A, Part B, Part C, Part D, this differentiation was done away with when in the year 1956, on the basis of the report of the States Reorganization Commission, a law was passed called States Reorganization Act 1956. And it was this law in 1956 which created 14 states and 6 union territories. And it is this 1956 law which also talked about the creation of zonal councils. The argument was that let's look at the problems of one particular zone and try to address these problems. And that is how 5 zonal councils were created. Northern, Eastern, Western, Southern, and Central. These 5 zonal councils were created by the States Reorganization Act of 1956. But then the year was 1971, when Northeastern Council was created, specifically for the states in Northeast. But this 6th zonal council, which is known as the Northeastern Council, it was not created by the States Reorganization Act of 1956. It was created by Northeastern Council Act of 1971. That's what the question is asking. All the 6 zonal councils are statutory bodies created under the States Reorganization Act 1956. All these zonal councils are statutory bodies, but 5 of them are created by the States Reorganization Act of 1956, and 1 Northeastern Council is created by the law passed by the Parliament in the year 1971. So the statement 1 is incorrect. The Prime Minister is the chairman of all the zonal councils. This statement is wrong. Who is the chairman of all these zonal councils? Home Minister. The Union Minister for Home is the chairman of all zonal councils. Union territories are not represented in the zonal councils. You have to be absolutely clear. Are these zonal councils only consisting up of the states? No, zonal councils have representation of union territories as well. Which of the above statements is or are correct? D. None of the above is correct. Clear? Let's look at another question. Consider the following statements. The Supreme Court in 2021 completely struck down the 97th Constitutional Amendment Act that sought to provide a clear framework for the administration of cooperatives. Let's look at the background. The year was 2011. 97th Constitutional Amendment Act was passed. And this constitutional amendment can be relevant for your prelims examination because this judgment was in the news. It basically amended 3 areas of the Constitution. Which are these 3 areas? It added or it amended Article 19(1)(c) of the Constitution. Article 19(1)(c) gives the fundamental right to every single citizen of this country to form a union, association, and cooperative societies. So this fundamental right for every citizen, that you have a fundamental right to also form a cooperative society, this fundamental right was given by the 97th Constitutional Amendment Act 2011. Another thing which was added, Part 9B was added, which deals with cooperatives. For example, we have 25 parts of the Constitution. Part 1 deals with, can be important in match the following types questions. Part 1 deals with union and its territory. Part B deals with citizenship. Part 3 deals with fundamental rights. Part 4 deals with directive principles of state policy. Part 4 capital A deals with fundamental duties. Part 5 deals with union. Part 6 deals with states. Part 7 was repealed by 7th Constitutional Amendment Act in 1956. The same year, when the states were reorganized in this country for the first time, in the same year, the 7th part of the Constitution was repealed. Part 8 deals with union territories. Part 9 deals with panchayats. Part 9A deals with municipalities. And Part 9B deals with cooperative societies. This was another thing which was added by this 97th Amendment. And the third thing which was added was Article 43 capital B. And Article 43 deals with directive principles of state policy. The Constitution was amended to say that it shall be the endeavor of the state to ensure that cooperatives are created and also ensure the democratic control of these cooperatives and also ensure that these cooperatives are professionally managed. These were the three things or three key amendments of 97th Constitutional Amendment Act 2011 can be relevant for your prelims examination. But then something else happened. Mr. Rajendra Shah, he approached the Gujarat High Court, challenged the 97th Constitutional Amendment Act. Why? The challenge was not why do we have another fundamental right. The challenge was something to do with federalism. And that is why, since federalism is the talk of the town, everybody seems to be talking about federalism. The allegation is that the central government is against the spirit of federalism. There is no cooperative federalism, there is coercive federalism. Whether right or wrong, we don't have to be concerned with that. We just have to understand what is the issue. The issue is that of a federalism or federal structure. This amendment was challenged on the grounds of violating federalism. Why? In the distribution of powers under Schedule 7 of the Constitution, cooperative society is under state list. Cooperative society is under state list. So any item which is under the state list, who has the power to make a law? State legislatures. So why is Parliament passing a law on an item which is within the legitimate domain, which is within the prerogative of the states under the state list? That was question number 1. Question number 2 was that there are some cooperatives which are functioning within a state. There may be a cooperative functioning only in Maharashtra. There may be a cooperative functioning in Tamil Nadu only. There may be a cooperative which is functioning in Maharashtra as well as Gujarat, in Andhra Pradesh as well as Telangana. So those cooperatives which have multi-state operation, which are working in different states, for that Parliament may have the power to regulate. But what about those cooperatives which are functioning only within a particular state? That power should not be given to the Parliament to regulate. That power should be only with the state legislatures. This was question number 2, saying that if Parliament is given this power to regulate all these cooperatives, then it is against the spirit of federalism because you are violating Schedule 7 of the Constitution. And at the same time, Supreme Court said, you're right. You can still change this. but for that you need to pass a different set of Constitutional Amendment Act. What does that mean? In how many ways can we amend the Constitution? This is where some of the students have doubts, possibly because of reading too much Lakshmikant. Constitution can be amended by simple majority. Constitution can be amended by special majority. And there are those provisions which are known as the federal features of the Constitution. If you want to change those features of the Constitution, you need ratification by half of the states as well. Right or wrong? Constitution, and listen to me carefully, Constitution cannot be amended by simple majority. Never. But there are some changes which can be made to the Constitution by simple majority, but the Constitution itself says those changes shall not be deemed as the amendment of the Constitution under Article 368. So whenever you want to make changes to the Constitution by simple majority, that is not amendment, because amendment can only be done by special majority. And which are these things which you can change in the Constitution by simple majority? For example, creation of a legislative council, providing that English can continue as the official language of the Union beyond a period of 15 years, increasing the number of judges to the Supreme Court. All these changes can be made by simple majority. But Constitution itself says that these changes shall not be deemed as amendment to the Constitution, because Constitution can be amended only by two ways, either by special majority, and whenever you touch upon the federal features of the Constitution, you need ratification by half of the states as well. Supreme Court said this Constitutional Amendment Act, which was passed in 2011, it did not seek the ratification by half of the states. That is why Supreme Court struck down this 97th Constitutional Amendment Act partially, not completely, partially. Why? Because Supreme Court had no issue with Article 19(1)(a). Supreme Court had no issue with 43(B), Directive Principle. Supreme Court only had issue with Parliament becoming empowered to pass a law for the management of cooperatives which are within a particular state. But Supreme Court said, if there is a cooperative society which is operating in multiple states, for those cooperatives which are operating in multiple states, the Parliament will have the power to regulate, make law. But if there is a cooperative which is functioning only within a particular state, for that the power is only with the state legislature, not with the Parliament. This was the judgment of the court last year, a very important judgment. That is why this backdrop becomes very important. This question was not asked last year, but perhaps can be asked this year. Let's look at the question. The Supreme Court in 2021 completely struck down the 97th Constitutional Amendment Act that sought to provide a clear framework for the administration of cooperatives. This statement is wrong, because not completely, partially. The Supreme Court has stated that cooperatives operating in a single state and any form of legislation pertaining to them are strictly within the domain of the state government and state legislatures. This is correct. If there is a cooperative operating only within a particular state, the state legislature has the power to regulate them. And in matters related to multi-state cooperatives, the Parliament has the power to legislate. This statement is correct. So which of the above statements is or are correct? 2 and 3, C is the right answer. Let's look at another question. Which of the following statements is correct regarding the 10th schedule of the Indian Constitution? Which of these statements is correct? A legislator who resigns from his or her political party is automatically disqualified from the House. Now, 10th schedule was inserted into the Constitution. The year was 1985, 52nd Constitutional Amendment Act. And this 10th schedule is also known as Anti-Defection Law. Anti-defection law is in the news, has been in the news because of its blatant misuse and because of something spectacular done by the Supreme Court to prevent its misuse. It was misused in Karnataka, Madhya Pradesh, Goa, Manipur, in many states, and that is why it becomes a potential question for your examination. What are the provisions of anti-defection law? Number one, if I'm a legislator can be a member of Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. If I'm a legislator belonging to a house, if I voluntarily resign from my party, I will be disqualified. A member of a house belonging to a political party, if he or she voluntarily resigns from that party, you are disqualified. Provision number 2. If the legislator violates the whip issued by the political party, the legislator shall be disqualified. And here we need to talk about 3 types of whips. There is something known as 1-line whip, 2-line whip, and 3-line whip. 1-line whip, 2-line whip, a legislator can violate and no action can be taken. But if a legislator violates this 3-line whip, shall be disqualified. What is this 3-line whip? 1-line whip, 2-line whip? 1-line whip is basically telling a legislator that there is a session going on inside the parliament, you can attend. 2-line whip is there is a session going on inside the parliament and there is going to be a discussion on a particular bill, please participate. 3-line whip imposes an obligation. Obligation is there is a session of parliament going on, there is a discussion on a particular bill or a motion or a resolution, you have to vote like this. If the party says you have to vote against, if the party says you have to vote in favor, if you violate this directive, you will be disqualified under anti-defection law. But here is one more condition which is normally missed by the aspirants, is that 15 days are provided to condone this violation. Let's say I am a member of a political party X and there is a debate going on inside the parliament, there is a bill to be discussed, let's say for example, raising the minimum legal age of marriage for girls from 18 to 21. My party issues a 3-line whip saying, Mr. Sarmat, you have to vote against this bill. What if I vote in favor of this bill? 15 days are provided to my political party. My political party can write to the Speaker of Lok Sabha within 15 days that we don't have any issue with this gentleman violating our whip. That means if my political party writes to the presiding officer, writes to the Speaker within 15 days condoning my violation, I will not be disqualified. But if within 15 days my violation has not been condoned by my political party, then after the expiry of this 15-day period, I can be disqualified by the Speaker. Very important point. Third, if an independent legislator, if an independent member of a house who doesn't belong to any political party, I'm an independent member of the parliament. For example, recently an independent MP and her husband were arrested by the Maharashtra police because of some controversy surrounding the chanting of Hanuman Chalisa outside Matoshri, which is the residence of the Honorable Chief Minister of Maharashtra, Mr. Uddhav Thackeray. They were arrested. So independent. If an independent legislator joins a political party after the election, disqualified. And D, a nominated member. A member nominated to Rajya Sabha. If a nominated member joins a political party within 6 months of his nomination, he will not be disqualified. But if a nominated member joins a political party 6 months after her nomination, she will be disqualified. These are the provisions of anti-defection law. But something else happened. Without taking names, there was one MLA who was elected on the ticket of the Congress party in Manipur. And then he joined the BJP. Mr. T. Shyam Kumar is the name. He joined the BJP, he was made a minister as well. Minister in the sense, he became the forest minister in Manipur government. But then he was not disqualified. Matter went to the speaker. The speaker was asked, please disqualify Mr. T. Shyam Kumar because he has violated anti-defection law. The speaker is not taking any decision. Matter went to the court. Two judges of the Supreme Court, and this is where it becomes very important. Two judges of the Supreme Court. One of the judge was Justice Rohinton Fali Nariman. Used one of the rare powers of the Supreme Court, one of the plenary powers of the Supreme Court, under Article 142. Under Article 142, the Supreme Court can issue any order so as to give complete justice. And the powers of the Supreme Court under Article 142, these are plenary in character, unrestricted by the legislature, unrestricted by the executive. That means legislature cannot advise the Supreme Court, how can you use Article 142? Executive cannot dictate to the Supreme Court how, where, when can you use Article 142. This is a plenary, a rare, an extraordinary power available with the Supreme Court to give complete justice. And Supreme Court invoked Article 142 and dismissed T. Shyam Kumar. Normally, the minister is appointed by a governor. And this is where the doctrine of pleasure comes into picture. And the minister holds office during the pleasure of the governor. But this time, this minister is appointed by the governor, but this minister is removed by the Supreme Court using its plenary power under Article 142 of the Constitution. That is where it becomes very important. And after that, the Speaker of the Manipur Assembly took the decision and disqualified Mr. T. Shyam Kumar. Very important question. Let's look at the options. Which of the following statements is correct regarding 10th schedule of the Indian Constitution? A legislator who resigns from his or her political party is automatically disqualified from the House. Not automatically, the Speaker has to disqualify that defector, not automatically. So this statement is wrong. Courts cannot interfere in defection matters before the Speaker's decision. There used to be this loophole in anti-defection law where the courts were not in a position to interfere in a pre-decisional stage. For example, many years ago, Mr. T. Srinivas Yadav, he was the member of the TDP in Telangana. He switched sides, joined TRS, became a minister of cinematography and commercial taxes under KCR's government. He was not disqualified. Why? Because the Speaker did not act. Because under anti-defection law, there is no time period mentioned within which the Speaker has to take the decision. Now the Supreme Court has said in this case that the Speaker should take a decision within 3 months. That's the order of the Supreme Court in this case, in this Manipur defection case. But prior to that, there was no time limit on the Speaker within which he or she has to take a decision or had to take a decision. In fact, this matter went to the Andhra Pradesh and Telangana High Court because at that time, Telangana and Andhra Pradesh had a joint High Court and the High Court was helpless. High Court said, we are helpless, we cannot interfere at a pre-decisional stage. We can only review the decision of the Speaker, but we cannot take a decision before Speaker has made up his mind or made up her mind. But now, because of the Manipur case, where even before the Speaker is acting, the Supreme Court has taken a decision. So even before Speaker's decision, the courts can interfere. So courts can interfere in defection matters before the Speaker's decision. Third, a defector is barred from holding any remunerative political post. This is the correct answer. What is a remunerative political post? Any post for whom the salary is paid from the public money, from the public exchequer. So if you are a defector, you have been disqualified. And once you have been disqualified, you cannot be appointed to any remunerative political post by the government for which the money, the salary is paid out of the public purse. That is one condition in anti-defection law. And this provision was inserted into the Constitution thanks to former Prime Minister Atal Bihari Vajpayee. The year was 2003. So this was not the provision mentioned in the original 1985 amendment. This was done in the year 2003. But a defector is not eligible, is barred from holding any remunerative political post. C is the right answer. Let's look at another question. Which of the following is incorrect regarding the Members of Parliament Local Area Development Scheme, or MPLADS? In the news for a long time now, and in the news primarily because some of the Panchayati Raj institutions, they have been protesting against MPLAD scheme. Why? Because they feel that this scheme, MPLAD scheme, is encroaching within the legitimate domain of Panchayat. What is the scheme? This scheme is under, can be important for your examination, Ministry of Statistics and Program Implementation. There is a misconception amongst the students, some of the students, that under MPLAD scheme, 5 crore rupees every year is given to every member of the parliament. Money is not given. What MPs can do, they can suggest work to the district collector to the tune of 5 crore rupees every year. That means I'm a legislator, I can suggest, recommend works in my constituency for up to 5 crore rupees in a particular year. And it is the district collector who has to implement whatever works I am recommending. But if I'm a legislator, what will I recommend in my constituency? I will recommend maybe construct a school, lay down a road, construct a septic tank. Clear? But these are within the domain of panchayats. Under the 11th schedule of the Constitution, there are some powers which are given to the Panchayati Raj institutions. For example, agriculture, rural development, schools, poverty alleviation. All these are within the legitimate domain of panchayats. So panchayat have these powers, have these roles and responsibilities, but here is an MP who is directing the district collector that you perform these actions, these roles to the tune of 5 crore rupees in a particular year. So what is an MP doing? He is encroaching into the legitimate domain of panchayat. And that is why Panchayati Raj institutions, various important sarpanches and panches, they have recommended the complete delinking, eradication of this scheme, abolition of this scheme called MPLADS. But under MPLAD scheme, this is not available only to MPs, it's available to MLAs as well. So even MLAs can recommend works to the district collector, and this value of money changes. For example, in Kerala it is 6 crore rupees. In other states it can be 5 crore rupees. So different states have different rules of MPLAD. At the central level, we have Ministry of Statistics and Program Implementation, the nodal agency for MPLAD scheme. I am a member of the parliament belonging to Lok Sabha. I can suggest works to the tune of 5 crore rupees in my constituency only. Clear? But I am a member of Rajya Sabha. I can recommend works to the tune of 5 crore rupees in my state, the state from which I am elected. But what if I am a nominated member of Rajya Sabha? A nominated member can recommend works to the tune of 5 crore rupees in any part of this country. Lok Sabha MP only in his constituency. Rajya Sabha MP only in his state. Nominated MP in any part of this country. That is something that you have to keep in mind. And this MPLAD scheme, it was discontinued by the central government because of the COVID-19 pandemic. But now it is continuing. It has been restored. The implementation has been restored. That's why this question becomes important. It is a central government scheme under which only the elected MPs of Lok Sabha and Rajya Sabha can recommend development programs involving spending of 5 crore every year in their respective constituencies. Not only elected, even the nominated MPs can recommend works. So this statement is wrong. the scheme is under suspension owing to COVID-19 pandemic. No, it is continuing now. It was suspended, not now. C, both A and B, correct. This is incorrect regarding the members of Local Area Development Scheme. Statement D, the National Commission to Review the Working of the Constitution and the second ARC had recommended discontinuation of the scheme. This statement is correct. So this statement is correct, but the question is asking which of the statements are incorrect. A and B both are incorrect, so C becomes the right answer. Clear? Let's look at another question. Which of the following statements regarding National Investigation Agency is or are correct? NIA is now almost always in the news. Various chief ministers, they are raising issues. In fact, there is a state government, Chhattisgarh, which has filed a petition in the Supreme Court challenging the constitutional validity of the National Investigation Agency Act. Let's look at this act. This act was passed in the aftermath of 26/11 Mumbai attacks. Maybe a statement, potential statement for your prelims. In the aftermath of 2008 26/11 attacks, NIA was constituted, and NIA is a premier investigation agency which investigates the terrorist activities or the terror crimes. This NIA was amended in the year 2019. That is why it becomes important for your examination. In fact, when I told you that Chhattisgarh government has petitioned the Supreme Court challenging the validity of NIA Act, Chhattisgarh government is not challenging the amendments made in 2019. Chhattisgarh government is challenging the very law, the original law of 2009. Prior to 2019, there was some other provisions in this law. Now the scope has been expanded. Let's look at the expansion in the scope of NIA. Number one, now NIA can investigate extraterritorial crimes, crimes committed outside India. NIA, National Investigation Agency, is now empowered to investigate into the crimes which are committed outside the territory of India as well. That's change number one. And in this NIA, there is a schedule which talks about various offences. And if these offences are committed, then such offences can be investigated by the NIA. For example, murder, rape, dacoity, these are not the offences that will be investigated by the NIA. Then which are these offences which needs to be or which can be investigated by the NIA? That is mentioned in the schedule of NIA Act. Originally, this schedule talked about offences under UAPA, Unlawful Activities Prevention Act, Anti-Hijacking. These were, and there were few other crimes, terrorism. These were the original offences mentioned under the schedule which could be investigated by the NIA. Now more offences have been added. Offences which have been added in 2019 include cyber terrorism, include counterfeit currency, include human trafficking. Now one change which was made in 2019 was that now NIA can investigate crimes committed outside India. 2 more offences have been added. How? Let's say, for example, there is a crime committed in West Bengal. Let's say this crime is related to the counterfeit notes and currency. State police will get to know about this crime in West Bengal. state police has to inform the state government. The state government will look at these offences and say, okay, these offences are mentioned under the schedule of the NIA, so we will have to report to the central government. And central government within 15 days, this is a very important statement, central government within 15 days, it will then take a decision whether this offence is to be investigated by the NIA or not. And whenever NIA will conduct an investigation in a state, they don't need to seek the permission of that state. For example, CBI. CBI has the jurisdiction over Delhi or over the central government institutions. But if the CBI has to conduct an investigation in Jharkhand or Chhattisgarh or Madhya Pradesh or Maharashtra, they have to seek the consent, the general consent of the states. But that is not the case with NIA. If there is an offence which is committed in a state and that offence is mentioned under the schedule, NIA can conduct an investigation in any state without any specific consent of that state. Not just that, one more important thing. Whenever NIA men, employees, agents, they are investigating a case in a particular case, they have the same position as that of the local police officers. So same protection is available to these NIA individuals, NIA officials, as the position of the state police. And also, NIA can also, with the previous consent of the central government, transfer a case to the state government. This is a very important statement. Prima facie, it appears to you that this statement is incorrect, but it is correct. NIA, with the previous consent of the central government, can transfer a case to the state government, asking the state government that you can investigate this case. And another important thing which was changed in 2019 is suo motu. Central government can ask NIA to suo motu take up the investigation of a case. On its own, you can take up a case. That is the power which is given to the NIA under the 2019 changes, amendments. Let's look at the question. Which of the following statements regarding NIA is or are correct? NIA cannot transfer any case to the state government for investigation. This is wrong. NIA can, with the previous consent of the central government, transfer a case to the state government. 2, central government can issue directions to the NIA to suo motu take over the investigation of a case. The statement is correct. The question is asking which of the following statements regarding NIA is or are correct. Only 2. B is the right answer. Correct? Let's look at another question. Which of the following statements is or are correct regarding the Foreign Contribution Regulation Act? FCRA again, it was in the news last year, it's in the news this year as well. It wasn't asked in last year's prelims, can be asked this time. Let's look at what is this FCRA. The original FCRA, Foreign Contribution Regulation Act, was passed in the year 1976. Indira Gandhi was the Prime Minister. 1976 is the year when nation was in a state of emergency as well. The emergency was imposed in 1975 on the grounds of internal disturbance. But be that as it may, under this law, some individuals were prohibited from taking any foreign contribution. Individuals such as candidates contesting elections, individuals such as the judges, individuals such as the publishers, cartoonists. These were the individuals who were barred from taking any foreign contribution. Why? Because the then Prime Minister, according to writers, according to historians, those who have followed that period, whoever was a critic of the government at that time, the Prime Minister or her party would say that these are instigated by the foreign enemies. So there is a foreign hand involved in these protests. For example, even when Jayaprakash Narayanan launched Sampurna Kranti, complete revolution from Bihar, asking for the eradication of corruption, she even alleged that there is a foreign hand involved behind these protests. And that foreign hand, she was alluding to CIA, Central Intelligence Agency of the United States. There were lots of problems with this law. That is why this law was replaced by a different law, and that different law was passed in 2010. And it is this different law which was amended in the year 2019, and that is why it becomes important for your examination. And the amendment which was made to FCRA 2 years ago, it basically included or introduced another set of individuals who cannot take up foreign contribution, and that individual is a public servant. So now in the list of individuals who cannot take foreign contribution, another addition has been made, that of a public servant. That's number one. Number two, let's say for example, I'm running an NGO. Can my NGO seek donations? Yes. Can my NGO seek donations from foreign countries? Can my NGO accept donations from foreign countries, foreign institutions, foreign organizations? Yes. But for that, FCRA license is necessary. Without this FCRA license, I cannot take any donation from any foreign country or foreign institutions or foreign organizations. Now, when this foreign FCRA license is expiring, I also need to renew it. Significant changes were made for this renewal as well. The government says, according to this law, which was changed in 2019, whenever any organization will ask for renewal of this FCRA license, central government may conduct an inquiry. Various organizations, their FCRA licenses were cancelled. Ford Foundation, Amnesty International, Greenpeace, many other organizations, JNU. What is the purpose? Whenever an organization wants to seek a renewal of this FCRA license, this law, which was changed in 2019, it says that central government may, before renewing this license, FCRA license, may order an inquiry. Inquiry to check three things. Check number one, if this organization is a benami or a fictitious organization. We have to check it. If it is fictitious, if it is benami, we will not renew the FCRA license. When we will not renew the FCRA license, which means you cannot take up the foreign donation. Second, we will conduct an inquiry to check whether this organization is responsible for communal tension. Or whether this organization is responsible for religious conversion. And the third thing that we will inquire into before we can give you the FCRA license or renewing your license is we have to also look at if you are not misutilizing your funds. If the funds were given to you to support people who are suffering from leprosy, are you misusing those funds for religious conversion instead? Or for spreading communal poison instead? Or for lavishly spending in the 5-star hotels and parties for your own employees? We have to check whether you are misutilizing your funds. Only once we are satisfied that neither is your organization benami or fictitious, neither is your organization responsible for spreading the communal tension or for religious conversion, and neither is your organization misutilizing your funds, then we can give you FCRA license. Prior to 2019, there was another condition. The condition was 50% of these funds can be used for administrative purposes. I run an NGO. This NGO is responsible for providing good quality education, free education to people in rural India. But I also get donation from the foreign organizations. I have the FCRA license. The law said that up to 50% of your donations you can spend for administrative purposes. I can spend 50% of the donations that I've got for paying salary to my employees or for paying rent to my office. Now this 2019 amendment which was made, it has slashed this percentage from 50 to 20. Now you can spend only up to 20% of your funds for administrative purposes. Not just that, another change has been made. What is the other change? Previously, if I'm running an NGO, I have this FCRA license, which means I can take up foreign donations and foreign contributions, and I could have deposited this donation in any bank account of my choice. Now the government says, according to this law, is that we will specify in which bank you can deposit this foreign contribution. And we are telling you that in the Parliament Street in Delhi, there is a branch of the State Bank of India. Only in that specific branch you can get these foreign contributions deposited. What if the SBI employees are sleeping or on lunch break? That doesn't matter. But be that as it may, the central government will specify in which branch of that bank the foreign donation can be accepted. And by notification, the central government has said that in Parliament Street of the State Bank of India branch, State Bank of India branch Parliament Street, these foreign contribution donations can be accepted. So any NGO or every NGO which wants to take up foreign contribution has to open a bank account in the Parliament Street branch of the State Bank of India and get these foreign donations deposited only in that specific branch. These are the big changes made to FCRA. That is why some NGOs are protesting. They are saying that it is curbing our intent, it is curbing our vision. We are not able to perform. We are going to only document our proposals. We have to open a bank account in Delhi. It's not manageable for us, so on and so forth. This is the controversy. Let's look at the question. Which of the following statements is or are correct regarding the Foreign Contribution Regulation Act? Number one, under the Act, a registered person must accept foreign contributions only in a single branch of a scheduled bank specified by him or her. No. Single bank, State Bank of India. Single branch, Parliament Street. And this is the bank which is specified by the central government, not by you. So this statement is wrong. A person who receives foreign contribution must not use more than 50% of the contribution for meeting administrative expenses. This number has been slashed to, this percentage has been slashed to 20%. So this is incorrect. The question is asking, which of the following statement is or are correct? None. D is the right answer. Let's look at another question. The FCRA provides that the government may conduct an inquiry before renewing the certificate to ensure that the person making the application is not fictitious or benami, correct? Has not been prosecuted or convicted for creating communal tension or indulging in activities aimed at religious conversion. Prosecuted or convicted, not only accused. If you are prosecuted for religious conversion, if you're prosecuted for creating communal tension, then your FCRA license will not be renewed. And third, has not been found guilty of diversion or misutilization of funds. All these statements are correct. What is the question asking? Which of the following statements are correct? D. All of the above is the right answer. Correct? Now let's look at something else. Which of the following statements is or are incorrect regarding the Right to Information Act? And why is this question asked? Because again, significant changes were made to Right to Information Act in the year 2019. Take a look at this question. and I'll give you 1 minute. You tell me what is the right answer, or you tell yourself what is the right answer. Right to Information Act was passed in the year 2005. We don't have to go too deep into the details of the RTI, but under RTI, Central Information Commissioners and Information Commissioners were appointed by the central government, were appointed by the President. They were given the same powers, same salaries as that of the Chief Election Commissioner and that of the Election Commissioners. So Central Information Commissioner will be given the same salary as that of the Chief Election Commissioner. Information Commissioners will be given the same salary as that of the Election Commissioners at the Election Commission of India. Now in 2019, the law was changed. Now the law says the term of CIC and IC, this tenure, shall be specified by the central government. Prior to 2019, the term of the CIC and ICs was 5 years. Now, what is going to be their tenure? That will be specified by the central government. That is why there are some individuals who are saying that you are diluting the RTI Act. Because if those who are responsible for the implementation of RTI, if they don't have the security of tenure, that means they will come under the influence of the central government, then you are weakening the RTI movement in this country. But be that as it may, the change which has been made is that the tenure of these individuals shall be specified by the central government. And the salary also shall be specified by the central government, because previously the salary was same for Central Information Commissioner as was the salary for a Election Commissioner of India or the Chief Election Commissioner of India. Similarly, the salary for the Information Commissioner was same as the salary of the Election Commissioners. The government may be right. Why? Because Central Information Commissioner or the Information Commissioner, these are basically statutory positions. But Election Commission of India, Election Commissioners and Chief Election Commissioner, these are constitutional entities. And giving the same status to a statutory body as the status you give to a constitutional body doesn't make sense. So that's okay. So these were the two significant changes which were made. Let's look at the question. The Chief Information Commissioner and Information Commissioners hold office for a term of 5 years. Previously they used to. Now the term will be specified by the central government. The salary of the CIC and ICs at the central level will be equivalent to the salary paid to the Chief Election Commissioner and Election Commissioners respectively. Now the salary shall be determined by the central government. The question is asking which of the following statements are incorrect. Both these statements are incorrect. C is the right answer. Let's look at another question. Operation Pangea 14 deals with lakhs of websites, lakhs of web links were taken down, and it was a joint operation by police, customs officials, health regulatory officials in more than 92 countries of the world. And this operation was coordinated by International Criminal Police called Interpol. And the headquarters of Interpol, may be asked in your examination, is in a beautiful French city, Lyon. So what was this operation all about? That is known as Operation Pangea. The target was that these illicit medicinal products, narcotics, which are sold on the internet through web links and websites, those should be stopped. So in this operation, which was coordinated by Interpol, which is headquartered in a French city, Lyon, more than 92 countries participated in this exercise and took down lakhs of websites, web links, which were selling illicit drugs, harmful drugs. So this operation was against the sale of fake and illicit medicines and medical products. To confuse you, I have given another option. Statutory provisions under Indian Antarctic Bill 2022. Let's look at what is this Indian Antarctic Bill 2022, which is in the news, which has not been passed by Parliament yet. It is pending in the Parliament, but let's look at the provisions. The Antarctic Treaty it was signed by India in 1959. 1959. The government of India says under this treaty, we are under the obligation that we need to pass a law. And this law should deal with preventing the illicit operations in research centers in Antarctica. Treaty Antarctica, signed in the year 1959, the government says we are under the obligation that we have to ensure that we make rules to prevent unlawful activities conducted at the research stations in Antarctica. And that is why Dr. Jitendra Singh, who is the minister involved, introduced a bill in the Lok Sabha called the Indian Antarctic Bill 2022. According to this law, according to this bill, there will be a central authority and this central authority will issue permits. So this is big provision number one. A central authority will be created under this bill which will issue permits. That means if you and me, we want to go on a research expedition to Antarctica, we can't go on our own, we have to take the permission of the central authority. That's number one. Number two, this bill also talks about some permissible, some prohibited things. What are the things which are permissible for us to do in Antarctica? What are the things that are not permissible for us to do in Antarctica? That will also be mentioned in this bill, in this law. For example, if somebody is conducting a nuclear explosion at any research station in Antarctica, this can be important for your prelims because prima facie it appears that this is a wrong statement. But if somebody is performing a nuclear explosion in a research station in Antarctica, for that the minimum fine is 50 crore rupees. Minimum punishment is 20 years in jail, which can be extended to life imprisonment as well. And the unique thing about this law, or unique thing about this bill, is that this bill will be applicable to foreigners as well. This is where some people say that Parliament does not have the competence to pass this law. How can Indian Parliament pass a law which will be applicable to the foreign citizens as well? Because if we look at the law-making power, Parliament has the power to make extra-territorial legislation, to make a law which is valid even outside the territory of India, but only for those citizens of India. That means the law passed by the Parliament of India is applicable to Indian citizens and their property outside India as well. But how can Parliament of India make a law which will be applicable to foreigners as well, that too outside India in Antarctica? The government is justifying, saying it's not that we want to pass this law for every foreigner. We are only passing this law so that even the foreigners who are working at the research center or station which is there set up by India, So even those foreigners working in these research stations in Antarctica will be subjected to this law. And at the same time, another important detail that may be relevant for your prelims examination is that there are 40 permanent research stations in Antarctica right now. 40. Out of them, 2 are Indians. One is Maitri, the other is Bharati. These are the 2 permanent research stations in Antarctica of India. So that is something, these are few important provisions dealing with Indian Antarctic Bill 2022, but Operation Pangaea, you may be confused Pangaea with Antarctica. Operation Pangaea is not associated with Antarctic Bill. It is the operation against the sale of fake and illicit medicines and the medical products. Let's continue and look at the National Security Act. But before that, why don't you press the like button? So if we have close to 1.6 thousand likes, let's see how much will it increase. Let's do a slight exercise. So if all these 1800 students, if you haven't liked this video yet, you might want to like it now. So let's see what increase would it lead to. And come on, it doesn't take a lot of time for you to press the like button, or does it? Right. Now it's getting up. Okay. Which of the following statements is or are correct regarding the National Security Act? National Security Act in the news because some individuals have been arrested by central government, by the state governments as well. This National Security Act is basically a preventive detention law. We know there is something called Article 22 of the Constitution. What does Article 22 say? There are some safeguards available to individuals after their arrest. Article 22 is not a fundamental right against arrest. It's not a fundamental right that you cannot be arrested. But there are protections which are available to individuals even after their arrest. And these provisions are kicked by Article 22 of the Constitution. And which are these provisions? One, I should be informed. What are the grounds on the basis of which the police is arresting me? So that I can call my lawyer, so that I can set up my legal defense. And within 24 hours of my arrest, I have to be produced before the magistrate. So information and me being produced before the magistrate, before the judiciary, is one of the important criteria, guidelines, provisions, safeguards available to me, given to me by the Constitution under Article 22. But there are 2 exceptions. The protections under Article 22 are not available to enemy aliens, and they are not available to those who are booked under preventive detention laws. And one such preventive detention law is the National Security Act. India has a long history of these preventive detention laws. This is where we will marry polity with history. In history, for example, Bengal Regulation 3 of 1818. This was a preventive detention law during the colonial period, where if it is assumed that you are a threat to the defense, to the public order, you can be arrested. And when you are arrested, that means you are not convict, you have not committed any crime, but we are assuming that you may be a threat to the defense, you may be a threat to the public order, we can arrest you under Bengal Regulation 3 of 1818. Then we had another Bengal Regulation Act of 1829 when William Bentinck was the head. This is when sati was abolished, but that's a different matter. Then came 1 century later, more than 100 years later, Roblot Acts of 1919. Basically, these were two Roblot bills against which there was a lot of protest, and this is when Dr. Saifuddin Kichlu and one more individual were arrested. People were protesting against that. That is when the horrific Jallianwala Bagh massacre took place in April 1919. Roblot bills, this was also a preventive detention law, wherein you can be arrested even without trial. There is no trial as well. And this is when Mahatma Gandhi fought against these Roblot bills as well. After the independence of India, we had Preventive Detention Act of 1950. But this Preventive Detention Act of 1950, it lapsed in 1969. Because it was only passed till 1969, for 20 years, December 31, 1969, it lapsed. And then came Shrimati Indira Gandhi. The parliament passed a law called MISA, Maintenance of Internal Security Act, under which writers, journalists, activists, student leaders, trade union leaders, opposition leaders were arrested during the emergency period. This MISA was repealed when the Janata Party came to power in 1977. But then when Indira Gandhi came back to power in the year 1979-80, National Security Act was passed by the parliament. And it is this National Security Act which is a preventive detention law. And under this preventive detention law, I can be arrested. I have not committed any crime, but I am prevented from committing a crime. I can be arrested under the National Security Act. And I cannot consult my lawyer. An advisory board is constituted by the government. This advisory board will tell me whether I am accused of some crimes, which crimes I am accused of, but I cannot have my legal defense. No lawyer will be represented. In fact, no FIRs are also registered because it's a preventive detention law. Since this law, the allegation has been misused, used, overused, abused in the recent past, this can be a potential question for your prelims examination. Let's look at the questions. Let's look at the statement. Which of the following statements is or are correct regarding the National Security Act? Number one, the Act was enacted in 1980, correct. It's a preventive detention law, absolutely right. The Act can be invoked only by the central government, no. Can be invoked by the state government as well. This is where the allegation is that the UP government is invoking these laws more vigorously. Fourth, the National Crime Records Bureau. There is a bureau, National Crime Records Bureau, which is a portal which details all the crimes committed in India, which collects and analyzes crime data in the country, does not include the cases under the NSA in its data. Yes, it does not. Why? Because no FIR is normally registered in NSA. When NSA is invoked, when no FIR is registered, that means on this data is not getting captured in the NCRB because NCRB takes a look at the FIRs. So this is correct. 1, 2, 4. C is the right answer. Let's look at another question. And this type of question has been, if not thrice, but at least 4 or 5 times has been repeated by the UPSC in the past many years. Parliamentary democracy. And what is parliamentary democracy? Parliamentary democracy means Council of Ministers is accountable to lower house of the parliament called Lok Sabha, which means the Prime Minister and his Council of Ministers, they are collectively accountable to Lok Sabha. They continue to remain in office as long as they enjoy the confidence of the Lok Sabha. The moment they lose the confidence of the Lok Sabha, they have no other option but to resign. That is why we say that there is a distinction between the parliamentary democracy practiced in India and the presidential democracy which is practiced in United States. In presidential democracies, they focus more on stability. We say the government in US is stable. The government in India may not be stable. Why? Because the government, Prime Minister and his Council of Ministers, they have to have the confidence in the Lok Sabha. The moment they lose the confidence, they have to resign. But Joe Biden belongs to the Democratic Party. Whether the Democrats control House of Representatives or Senate or not, whether they are in minority or majority, doesn't matter. Joe Biden is going to complete his 4 years, provided he survives this term of his. But be that as it may, the point is that in a presidential democracy, they focus more on the stability of the government. But in a parliamentary democracy, we focus more on the accountability. The government should be accountable to the lower house of the parliament. And that is what parliamentary democracy is. Let's look at the question. Which of the following statements is or are correct? Parliamentary democracy means collective responsibility of the Council of Ministers to the popular house of the parliament. Rajya Sabha is known as the House of Elders or the upper house. Lok Sabha is known as the lower house or the popular house of the parliament. Why popular house? Because Lok Sabha consists of members who are directly elected by the people. So they are popular among the people. Not popular among the people, they are directly elected by the people. They are directly accountable to the public as well. They are susceptible to the popular demand of the people. That's why we call it the popular house. This is correct. The preference for a parliamentary democracy by the Constituent Assembly can be viewed as a preference for more responsibility rather than more stability of the governments. In prescribing parliamentary democracy, we can say that the constitution makers, they have focused on accountability and not the stability of the governments. So this is correct. So which of the above statements, following statements is or are correct? C, both is the right answer. Let's look at another question. Pradhan Mantri Jan Vikas Karyakram is a program which, whether right or wrong, true or false, correct, incorrect, we don't know. But there is an allegation against the central government that it is targeting the minorities. Minorities, quote unquote, are not safe in India. In this backdrop, UPSC may focus on questions, on programs, on schemes which are specifically targeting the minorities, which are specifically focusing on the minorities. Can be a question for your prelims examination. Let's focus on two such schemes because they wed minorities with skill development. Let's look at these two programs. Pradhan Mantri Jan Vikas Karyakram is a program which it seeks to provide better socio-economic infrastructure facilities to the minority communities. Let's look at something more on this. The year was 2008 when MSDP was launched. MSDP is Multi-Sectoral Development Program. What is this multi-sectoral development program? This program identified MCDs. Which are these MCDs? Minority concentration districts. And what is the definition of these minority concentration districts? Those districts where at least 25% population belongs to the minority community. Now, which are these minority communities? These minority communities are created or given status by National Commission for Minorities Act of 1992. And under this National Commission for Minorities Act, we have 6 religious minorities: Muslims, Christians, Sikhs, Buddhists, Jains, and the last minorities added to this list were the Parsis. The declining number of the Parsis, for them there was a campaign launched called Geo Parsi. That's a separate matter altogether. The point is, 2008, Multi-Sectoral Development Program was launched. Ministry of Minority Affairs was responsible for this. The idea was to identify minority concentration districts in this country. Which are these minority concentration districts? Where at least 25% population belongs to the minorities. Which are these minorities? Those minorities defined by the National Commission for Minorities Act 1992. And in these minority concentration districts, skill development, education, health infrastructure will be focused upon. That was the purpose of Multi-Sectoral Development Program. The year was 2013. This Multi-Sectoral Development Program was restructured. Restructured in the sense that now we started looking at minority concentration blocks, minority concentration towns, and cluster villages. So the focus shifted from districts, now the focus shifted on villages, towns, blocks as well. And it is in these minority concentration areas that this Pradhan Mantri Jan Vikas Karyakaram is implemented since 2013, and the idea is to provide better socio-economic infrastructure facilities to the minority communities. And the focus is mostly on education, the focus is on health, the focus is on skill development, and even there the focus is more on women community. So that is Pradhan Mantri Jan Vikas Karyakaram. Let's look at another question. Consider the following statements. Seekho or Kamao is a scheme implemented since 2013-14 for the skill development of minorities. The minimum qualification for a trainee is matriculation. Seekho or Kamao, Urdu word. It basically means learn, Urdu phrase, learn and earn. This was the scheme, and this is the scheme which is launched which is under the aegis of the Ministry of Minority Affairs. And this is implemented since 2013-14, and the purpose is the skill development of minorities. This is correct. How? If we look at minorities, the condition of minorities according to various reports, committees is abysmal. And that is why some specific programs are tailor-made for the minorities. The purpose of this program, Seekho or Kamao, the principal objective is to reduce unemployment amongst the minorities. Clear? But these minorities, they also practice some of the crafts. Crafts such as glassware, carpet viewing. They also practice some wooden works, embroidery. So the minorities who participate in these crafts such as embroidery, woodworks, glassware, knitting, ultimately the purpose is to provide the members of the minority community skills. And through these skills, 2 objectives are served. One objective is that we preserve these traditional crafts, and at the same time, once we preserve these traditional crafts, because we provide skill development in these areas to the members of the minority community, so their skills are being preserved, and at the same time we allow and ensure that we reduce the unemployment of these minorities, because now they are better equipped to find a job in the open job market. For that, various agencies are recruited which provide these skill development programs to the minorities. But for that, we have some eligibility criteria. The trainee who should be trained, who will be imparted training in skill development, this trainee should belong to minorities. And which are these minorities? The same minorities defined by the National Commission for Minorities Act 1992. Second, age is an important factor. So the age group which is targeted is 14 to 45 years. Can be potential statement for your prelims exam. And C, minimum qualification is also required. And the minimum qualification which is prescribed under this SICO or CAMAO program is class 5. Those who have completed class 5 in the age group of 14 to 15 should belong to these minorities defined by the National Commission for Minorities Act 1992. They will be provided training, skill development by various entities, agencies in these traditional arts and crafts. That is what SICO or CAMAO is. So SICO or CAMAO is a scheme implemented since 2013-14 for the skill development of minorities. Yes, the minimum qualification for a trainee is matriculation. No, the minimum is class 5 or standard 5. So the statement 2 is incorrect. Which of the above statements is or are correct? A, only one is the right answer. But even here, to conceptualize this scheme, there is one body which is responsible for this, which has played a very important role in conceptualizing the scheme. And that body, that entity is National Productivity Council. So if the question is not asked on Khelo or Kamao, SICO or Kamao, the question is not asked on Pradhan Mantri Karyakram, the question can, Jan Vikas Karyakram, the question can be asked on National Productivity Council. And it is this body which is under the Department of Promotion of Industry and Internal Trade, which is a department under the Ministry of Commerce. This department or this National Productivity Council, what it basically does, it conducts training, imparts training, gives consultancy services, provides training in the areas of, let's say, agri-business, information technology, in various other fields, consultancy areas. And this National Productivity Council has played a very important role in conceptualizing these schemes. So look at the statement. This National Productivity Council was established in 1958, correct? It is an autonomous organization under the Department of Promotion of Industry and Internal Trade, which is under the Ministry of Commerce, correct? It is a constituent of the Tokyo-based Asian Productivity Organization. Yes, this is also correct. In fact, India is one of the founding members of this Tokyo-based Asian Productivity Organization. All these statements are correct. D, all of the above is the right answer. This might appear to be a very difficult question for you, but this is pure fact, and sometimes UPSC does ask facts in the prelims. Let's look at another question. Which of the following statements is or are incorrect? And this is related to the reservation for the economically weaker sections of the society. This case is pending before the court. A 5-judge constitution bench of the Supreme Court is hearing this case. In fact, recently there was a hearing as well. And in this hearing, the Supreme Court had asked the government that you should reconsider, revisit the eligibility criteria for EWS reservation, because EWS criteria is similar to the criteria for the OBC reservation. The government agreed, said we are going to rework on this, we'll come back to you. And once the government went back to the Supreme Court, the government defended its EWS criteria, saying it is justified and we have consulted a lot of people and our classification is justified. So the case is pending before the court, and the hearing has also taken place recently, That makes this a potential question for your prelims examination. We have reservation for SCs, STs, OBCs. Clear? Now, all those who are not covered under this existing scheme of reservation, if you are not SC, ST, OBC, which means you are not from these reserved categories, but if you are not from these reserved categories, you are from other category, the general category, but you are poor, you will be provided 10% reservation in direct recruitment. And this is something which was done by a Constitutional Amendment Act, 103rd Constitutional Amendment Act, 2019. Another issue regarding this reservation is that it has extended the total reservation beyond 50%. If SCs are provided reservation to the tune of 15%, STs 7.5%, OBCs 27%. On top of that, now we are providing 10% reservation to economically weaker sections of the society. It means we are reserving up to 59.5% of the seats, which violates the cap, the limit imposed by the Supreme Court in a landmark Indra Sawhney versus Union of India. In this case, the Supreme Court had said that reservation cannot exceed beyond 50%. It can exceed beyond 50% only in extraordinary circumstances. This is where it becomes even more important, because Maratha reservation was provided by the state of Maharashtra to the Marathas in government jobs and in educational institutions. It was struck down by the court. The Supreme Court struck down Maratha reservation, saying that you have not provided any valid justification of this extraordinary circumstance under which you want to extend the reservation benefit beyond 50%. So this can be a question for your prelims examination. This limit that reservation cannot, under any circumstance, exceed 50%, but only in extraordinary circumstances, this limit was imposed in the landmark Indra Sawhney versus Union of India case of 1992-1993. But now this EWS reservation, who is eligible for this EWS reservation? Number one, if the annual gross family income is less than 8 lakhs. These conditions, this criteria is very important, can be asked in your prelims examination because there is a Supreme Court hearing specifically on these criteria. If you are holding an agricultural land above 5 acres, there can be no reservation for you. That means you are not poor. Similarly, if you hold a residential flat of 1,000 square feet, you are not poor, no reservation for you. If you are holding a residential plot of more than 100 square yards in notified municipal area, there can be no reservation for you. If you are holding a residential plot of more than 200 square yards in other than these municipal areas, in non-notified municipal areas, you are not belonging to the economically weaker sections of the society. Long story short, we have reservation for SCs, STs, OBCs. The year was 2019. Through a constitutional amendment, 103rd Constitutional Amendment Act, all those individuals who are not covered under the existing scheme of reservation, and if they belong to the economically weaker sections of the society, they shall be provided 10% reservation in direct employment and in universities, in colleges, and in government jobs. But how do we define who are individuals belonging to economically weaker sections of the society? For that, this is the criteria. Annual gross family income, and this family income can be from all sources, agriculture, salary, so on and so forth. Less than 8 lakhs, you are eligible. But if you hold an agricultural land above 5 acres, you are not eligible. If you hold a residential flat of above 1000 square feet, not eligible. A residential plot of 100 square yards or above, not eligible. A residential plot in a non-notified municipal area of above 200 square yards, you are not eligible. And the Supreme Court had said in Indira Sani case that reservation cannot exceed beyond 50% under any circumstance, except in extraordinary circumstances. And at the same time, the year was 1991. P.V. Narasimha Rao was the Prime Minister. At that point also, 10% reservation was provided to the poor. But this 10% reservation for the poor was struck down by the Supreme Court in Indira Sani versus Union of India. Why? Because Supreme Court in 1992-1993 said, Constitution of India recognizes backwardness only either social or educational backwardness. Constitution does not recognize economic backwardness. But if this was struck down, this reservation for poor was struck down in Indira Sani case, how is the government providing reservation now in 2019 onwards? There is a difference. When P.V. Narasimha Rao's government provided reservation for poor, it was done by a government order. The cabinet issued an order, the government issued an order, and through this executive order provided 10% reservation to poor. That order was struck down in the Indira Sani case. But this time what the government has done, it has not provided reservation through an executive order. It has provided reservation by amending the constitution, by introducing another criteria of backwardness, which is economic backwardness. That's the difference. Let's look at the question. Which of the following statements is or are incorrect? The persons belonging to economically weaker sections who, even if covered under the scheme of reservation for SCs, STs, OBCs, shall get 10% reservation in direct recruitment in civil posts and services in the government of India. No. Even if covered under the scheme, no. Those who are covered under SC, ST, OBC reservation, they are not eligible for EWS reservation. Right? That's why statement 1 is incorrect. Eligibility, income of less than 8 lakhs per year shall also include income from all sources, that is salary, agriculture, business, profession, etc. for the financial year prior to the year of application. You are applying for reservation today, we will look at your criteria over the past 1 year. So this statement is correct. Reservation in jobs for the poor was also provided by the central government in 1991 through a Constitutional Amendment Act which was struck down by the Supreme Court in Indira Sani case. This is incorrect. Why? Reservation was provided for the poor which was struck down in the Indira Sani case, but that was done by a government order, by a government resolution, not by the constitutional amendment, which was struck down by the Supreme Court in Constitution. So 1 and 3 are incorrect. Which of the following statements are incorrect? Reservation in jobs for the poor was also provided by the central government in 1991 through a constitutional amendment which was struck down by the Supreme Court It was struck down by the Supreme Court in Indira Sani case, but it was not done by a constitutional amendment. It was done by the executive order. The persons belonging to EWS who, even if covered under the scheme of reservation for SC, ST, OBC, shall get 10% reservation. This is also incorrect. 2 is correct. So the question asking which of the following are incorrect. 1 and 3. 1 and 3 unfortunately is not an option. So 1 and 3 is the right answer. Let's take a look at this again. The persons belonging to EWS who, even if covered under the scheme of reservation for SC, ST, OBC, shall get 10% reservation. They cannot, so 1 is incorrect, 2nd is correct, 3 is incorrect, 1 and 3 incorrect. 1 and 3 is the right answer. Okay. Let's look at possibly the last question that we might discuss today, because we are approaching 9:30. Okay, let's look at this. Which of the following statement is or are correct? According to the Constitution, the official language of the Union shall be Hindi. The Constitution imposes a duty on the Union to promote the spread of Hindi. The President can direct a state to declare a language as the official language of a state. Language is a tricky issue. I don't think you would have noticed that. Because you are busy preparing for this exam, you have no time to be on Twitter. Bollywood actor, Hindi film actor Ajay Devgan tweeted something to a southern movie actor, and that too in Hindi language, which generated a lot of controversy. Basically, Mr. Devgan is alluding to the fact that Hindi is the national language of India. We don't have a national language. There is only the official language. There is no concept of national language in India. In fact, this Hindi domination or imposition, it has its own history. It dates back to the controversy in southern India, particularly in the then Madras. All languages should be respected, but we don't have a national language. So this language, which is a tricky issue, there can be a question on this language. Let's look at the question. According to the Constitution, the official language of the Union shall be Hindi. Is this correct? This is correct. According to the Constitution, the official language of the Union shall be Hindi in Devanagari script. But the same Constitution further says that prior to the commencement of the Constitution, English was being used. So we can continue with the English even after 15 years. And that is how Official Languages Act was passed in the year 1963. And it is this Official Languages Act which says that both Hindi as well as English shall be the official language of the Union. In fact, Constitution had said that the official language of the Union shall be Hindi in Devanagari script, but we will use English for 15 years. That means till 1965. But this law of 1963, there is no time limit. There is no time limit to the continuation of English as the official language of the Union. But the question is asking, according to the Constitution, what is the official language of the Union? It is Hindi in Devanagari script. Number 2, the Constitution imposes a duty on the Union to promote the spread of Hindi. This is correct. Under Article 351 of the Constitution, it shall be the duty on the Union. It's not the duty on the states. It's only the duty on the Union. That what Union you will have to do? You will have to promote the spread of Hindi so that this Hindi language emerges as a medium of expression for all the elements of our composite culture. So there is a constitutional obligation on the central government to promote the spread of Hindi. That is why when some people allege that the central government is blatantly promoting Hindi at the expense of other beautiful South Indian languages, maybe this allegation is not correct, because Constitution has imposed a duty on the Union to promote the spread of Hindi so that Hindi emerges as the medium of expression for all the elements of our composite culture. Statement 3. The President can direct a state to declare a language as the official language of a state. What do you think? Yes or no? What do you think? Tell me fast. Yes or no? Yes or no? Yes. 1, 2, 3. All of the above is the right answer. One section of people in a state, if they are speaking a language and they feel that their language is not being respected by the state, is not recognized by the state, what these people can do, they can petition the President of India. And the President of India can direct a particular state that you have to declare a particular language as the official language of that state. This statement is also correct. Let's look at the question again. Which of the following statements are correct? According to the Constitution of India, the official language of the Union shall be Hindi. Correct. The Constitution imposes a duty on the Union to promote the spread of Hindi. Correct. The President can direct a state to declare a language as the official language of the state. D. All these statements are correct. That brings us to the closure, to the end of today's lecture. We have discussed lots of questions, lots of issues, lots of concepts, I think to the best of my capability. If you have liked this lecture, please press the like button. Comment once the video is over. That is one way of letting us know whether you are liking this initiative or not. And if you are really liking these initiatives, then you should also consider subscribing to our channel and share the links of these classes with your friends and fellow aspirants. I'll take a break today. I'll meet you again on Saturday and then again on Sunday. We'll discuss Polity Lecture 3, Polity Lecture 4. But from tomorrow onwards, you can dive into another set of fascinating lectures on economy, on art and culture, places and news, international relations, and many other subjects. So see you when I see you again. Till then, have a great time. All the best. Good evening.